Morning. Happy Friday. I'm going to wait for you guys to start tuning in. Happy Friday, Instagram, Facebook, YouTube. Let me put my phone number in the ticker right now. How's everyone's Friday going? If this is your first time, put let's find an emoji. Put a heart emoji in there and let us know it's your first time and let me know where you're tuning in from. If it's not your first time, still say hi and let me know where you're tuning in from. Just give me a second, guys. I'm trying to type in these numbers so I can pin it. As you know, it's hard for me to talk and type in numbers at the same time. Hi, Keela, Gifted Hands. Hi, Nimi, Janovic, Nadisha, I am Chefs. Thank you guys so much for tuning in. Let me introduce myself. My name is Aisha Chidole, and I'm an immigration lawyer. I represent clients all over the United States and internationally with their family immigration. So we handle VAWA cases, marriage-based cases, fiancé visas, consular processing if you're processing for your parents, your children, your spouse. We also handle U visas and T visas, as I mentioned, VAWA naturalization. So we can assist you with any of those. If you'd like to schedule a consult, call 407-995-6567. Or you can send a WhatsApp message to 404-333-8751. Okay, so today I just want to talk about some of the dreaded things that immigrants get from immigration and generally just how to navigate those. A big one is request for additional evidence, which is also known as an RFE. The second one is a notice of intent to deny. Good morning, Keisha on YouTube. Thanks for tuning in. So let's start with an RFE. Like I always tell my own clients, and like I'm, telling you guys now, when you get an RFE, which is a request for evidence, an RFE is not necessarily saying that your case is going to get denied. An RFE is basically saying that with the information they have, they cannot make a decision. And RFEs vary. Like there could be so many different things or reasons why you get an RFE. For some people, you might get an RFE because i.e. you don't submit the correct I-864 or your financial affidavit of support correctly, or your joint sponsor is not enough, like they don't make enough money. For other people, they might want DNA evidence if you're filing for like a parent and child. For other people, it just means that they need other evidence to prove your marriage or your relationship. In the case of VAWA, like some RFEs that you might get might be for good moral character. It might be for not only good moral character, it could also be for proof of cohabitation, proof of extreme cruelty. So all of these things, is essentially saying we've received this, we have what we need, but we don't have enough to make a decision. So submit this to us. It is very important that you take your RFE seriously. What I mean by that is if USCIS has like 1, 2, 3 things that they've asked you for, if you only submit 1, 2, they're going to make a decision based on that 1, 2, which most times will likely result in a denial. So you don't ever want to ignore any of the questions that you've been asked to provide clarity on in the request for additional evidence. You want to make sure that you give them all the information that they're asking you for. Because if, we see a lot of people come to us where they denied their green card application for simple things like just financial affidavit of support. But financial affidavit of support is such a complex requirement that it's never what meets the eye. It's never just, oh, show them your tax returns and you meet an income. There's just so much that goes into it that's very confusing, and even confusing for us as practitioners, because how they might look at income from a self-employed person, to someone that's using their assets for income. So basically, there's a lot of nuances that go into that. So it's one area though that you don't have to get denied by if you go with a professional that knows what it is that they're doing. So you want to make sure that your RFEs are being responded to. So now let us talk about the one that we really hate to see, which is a notice of intent to deny. So a notice of intent to deny, also known as a NOID, basically is the one that is like, gosh, why do we have this? So a notice of intent to deny usually means that we've seen everything that you've submitted, and there is something here that's causing us to want to deny you. And unless you make a legal argument of why we shouldn't deny you or provide, essentially proof that's contrary to what we see, we're going to deny you. In some cases, it's also called a notice of intent to revoke. That's typically in an I-130 situation where maybe if you're doing consular processing, and they first approve your I-130 and then they send it over to the National Visa Center, you might get back what we call a notice of intent to revoke, but treated the same way. Notice of intent to revoke, notice of intent to deny is kind of the same thing. Like, this is much more serious. With an NOID, you really need to pull out all the stops. It's not impossible to overcome an NOID. It is not impossible. But, NOIDs that come after interviews where maybe the two parties have like extremely differing answers to, their marriage and questions that they ask you, those tend to be really challenging, and really, really trying to understand from those clients, what would have caused you guys to have such different answers and things like that. So with those ones, we always want to be able to attack on those legal grounds and statistical grounds, like some arguments that I'll tell you that we've kind of made with NOIDs, where you've had a client where he just didn't remember like the date of birth of like his stepkids, or like what color something was, with stuff like that. One of the things that we've done is we've made arguments as to statistically men are not good with dates. Like, they don't remember dates, like, and that's true. Like, even my own husband, who is the only person who shares the same March birthday as my daughter, he actually confuses both their birthdays. So, but then there are other things that it's difficult to make arguments about, where it's completely different. Like, if a spouse is like, I don't know where we live. Like, what is your address? Like, where do you guys live? And they're like, I don't know. What city do you live in? I don't know. Like, those are hard to overcome, because any normal person who's married, unless you have like a clinical, like a diagnosed condition, should know that. So with your NOIDs, you definitely do not want to take those lightly. You want to speak with legal counsel and hire them to help you address that. So that's kind of what I wanted to talk about. And then just to talk about timeline for response. When you do get these, you always want to follow the timeline listed in the envelope. Now, due to COVID, and I don't have the date offhand, but as of right now, generally they're given that additional 60 days. So if, let's say, your RFE is 37 days or your NOID is 33 days, there's that additional 60 days due to the COVID grace, where they allow you to submit it, up to 60 days. I always am of the school of not waiting till the very last minute, because you don't want to rely on the US Postal Services or UPS or whatever. At the very maximum, you want to send it out at least a week before it's due, just so that there's no confusion as to whether your stuff got there or not. Okay. Good morning, John from Alabama on Facebook. All right, let me take some questions. So, my D official says, how long after replying to an RFE do you get a response from USCIS? So the answer, so it depends. There are some RFEs that you don't get a response; your case just continues. So, if you get an RFE for like an I-864, which is your financial affidavit of support, something like that, there's no response being gotten from USCIS. Your case is just continuing. If it's a normal RFE, you don't necessarily get a letter from USCIS saying we've received it. Sometimes, not all field offices will do this, but they'll update it in their online portal saying received correspondence or received RFE response on there. There's no timeline because it depends on where your RFE is coming from. If your RFE is coming from the local field office, is it coming from the benefits process center? So nobody can really give you a timeline. If it's something where like they're asking for an RFE for, let's say, like your medical, then usually shortly within that period, they're going to be making an approval of your green card. But otherwise, it's really hard to predict when you would hear back from USCIS, with regards to that. Okay, guys, you can ask me your questions. Let me take some of these questions. Marlene says, what is the next step after you do biometrics, and how long will you get a response from USCIS? Well, what did you do biometrics for? Did you do it for a marriage-based case? Because the timeline, the next step is different for everyone. So you can put that in a comment, and I'll be able to answer you. This is a very good question. Is video evidence presentable in a VAWA case? Unfortunately, no, you cannot present video evidence. However, something maybe you can do is you can take screen captures, still captures of the videos or the parts of the videos you want to emphasize. And then, people also ask about audio. They bring audio. One of the things we do is we have a company that we work with that transcribes, and they can transcribe that for you into an audio and certify the audio, but you can't send like videos and audios to USCIS. Basically, everything has to be in like paper format. I'm Jane said, I had my interview on December 2021, and I haven't had a response till date. What should I do? That's definitely a long time. You might want to consider congressional assistance, to try and see if you can get an answer. If no congressional assistance, you might want to consider a writ of mandamus, which is when you basically sue the government and tell them you need to make a decision because this is past, normal time. Nats the girl says, where are they with marriage-based cases in Atlanta? What do you mean, where are they? Like, I don't know what the question you're asking me is. Koku says, I did my biometrics for my adjustment of status in July of 2019, so August, September. I want to expedite my EAD. Do you think that will affect my case in any way if I decide to expedite? Well, it's not going to affect your case, but you don't make the decision on whether they expedite it or not. USCIS makes that decision, i.e. if you're a healthcare worker, or you can show extenuating circumstances of hardship that will allow them to expedite it. But if you did your biometrics in July, I don't know when you submitted your application, but you should be getting your EAD any day soon, though. Okay, let's see what else we have. Boss lady says, what if they send you a notice to deny? Okay, well, I think you probably typed this before you heard me talk about it, so you can go ahead and watch this video once it's done. Zernaima says, good morning. I received a VAWA approval back in February. On September 14, I got a mail to take the I-693, I-864W. What does this mean? That is really good news. That's really good news. So if you, without saying it, but if it's what I think it is. So basically, the I-864W is for those who are self-petitioning where you don't need a financial affidavit of support. So normally when you're filing an adjustment of status, you need to file an I-864. That's a financial affidavit of support. Um, form. But an 864W is basically a waiver that they're waiving, you're exempt from that. So in order for them to approve you for the green card, they need that form. And also the 693 is for you to do your medical. So if the letter is actually telling you to submit both things, it means that once you submit both things, that they will approve you for your green card. So that's exciting. So make sure you do it and send it before the deadline. All right, let's see what else. Jeff Pascal says, "Good morning, best lawyer in the world, my favorite lawyer. How are you doing today? Hope all is well." Yes, all is well. I am so sleepy today. I went to bed so late last night, but I'm just trying to get through the day. Jen Keita says, "Blessings, one of the best attorneys." Thank you so much. You guys are so sweet. Okay, do you guys have any other questions before I jump off? Let me see. How many days do I need to wait until USCIS sends a receipt notice after they receive your application by mail? The answer is it depends. I don't know what you filed, but most people will get their receipt notice within 3 to 6 weeks. Some people even earlier, but 3 to 6 weeks is the normal. I would say that the only time that we see like a really long delay is when you submit an I-360 without an adjustment of status application. It takes them a really long time. I always joke and say that USCIS, if you send them any application with money, USCIS is very quick to send you the receipt, but with an abeyance, it's free. Those ones, they waste time because they don't have to cash any money. So, okay. Okay, let me see what else. John says, "How long could I stay outside the US with a temporary travel card?" Not too long. Not too long. We don't recommend it. I mean, while there's no technical window, there's no technical date that says, stay out for this long, stay out for that long. Generally, one of the things that we advise our clients is that if you're going to leave the country, depending on what stage you are in your process, that should determine how long you stay. If you're closer to the interview time, you don't want to be out there too long where they schedule an interview and they don't give you enough time to get back. And then generally, if you've had your interview and you're waiting on a decision, I just generally feel iffy about recommending for travel outside of that time, just in case the decision is not good and then you're already out there and stuff like that. So, yeah. Hi, Lorraine from California. Keisha says, "Is it a problem if you submit your medical with your VAA application?" No, it's not a problem at all. You can choose to submit your medical with the adjustment of status or your VAWA application with adjustment of status at the time you're submitting it. Just different preferences. But if you don't submit it then, that's fine. You can take it with you to the interview, or if they decide that they're going to waive your interview, they'll ask you for it and then you can send it. So it doesn't really matter. You guys know that I generally submit mine towards the interview, but it doesn't matter how you submit it. The only times that I generally will submit it with the application is when mom is filing for child or child is filing for mom. Only then. Otherwise, we take it to the interview, or when they send an RFE asking for it, we send it to them. All right, let's see what else we have here. Okay, so Abugo says, "Good morning. My prima facie has expired since July, but I have not received my EAD or any response from USCIS. So your prima facie is not tied to your EAD, which is your employment authorization. Your EAD is tied to your adjustment of status application. As far as your prima facie, those come automatically. If you've not received one by now, because we're about to be in October, I definitely think that you should do an inquiry. Either have your lawyer do an inquiry through their attorney hotline, or you have to send a letter, because you can't call them. You can't call VAWA unit on the phone. Nobody will respond to you. The second thing is your EAD is dependent on when you filed and the processing time. I don't know when you filed, what you filed, as far as your category, if this is your first EAD, what class did you put in there? So there's just so much variables that without knowing, it's hard to say. SRO says, if someone is living in another country, can they get a police record from the country of their birth? Yes, they can get a police record from the country of their birth. And as a matter of fact, there are many immigration petitions that require that. So for instance, like if you're consular processing, meaning that the person you're processing for lives outside of the country, they definitely need to get their birth records from the country where every country basically that they've lived in since they were 16 years old. If you're in the US and let's say you're filing for a valid petition, like you just came 9 months ago, you submitted a valid petition or whatever it is, the only good moral character that we have here in the US is for 9 months. So we're going to still want to see the last 2 years because we have to show 3 years of good moral character. So in those cases, having a police clearance or police, record from outside the country will help your case, or they will send you an RFE for it. Okay. Let me see what else I have here. Okay, so it says, how long a marriage-based green card process is taken in Georgia this year? I would say maybe 12 to 15 months. You always have some cases where a decision can be made in 9 months or in 10 months. But if you're filing a marriage-based case, I always say just give yourself 12 months, for something or for an interview. Okay. Dustin says, best immigration lawyer. Thank you so much. Bella says, I received an update stating they reviewed my case. What does this typically mean? It means exactly what it is. It says it means that at some point soon, it depends on what's so is this an update that just said actively reviewing, or this has just been dormant? But typically, if you get an update that just happened, it means that they're either checking something on your case and they could be making any kind of decision or requesting additional information. So, I don't know what case you have, but that's what it could mean. Prodigy says, how long does USCIS take to send you your interview notes after RFE? You mean an interview notice? I don't know. I can't tell you that because there's no rule or requirement. They can do it whenever they want. Tedra says, good morning. Can you represent someone in California? Absolutely. We have many clients in California and in just about every state in the United States. I think maybe the only state we don't have yet is Alaska. But we have everywhere. So your location is not a problem. With immigration law, it's federal practice. So we can represent clients anywhere. It's not like a state law. Angelise says, good moral when a case is dismissed, how to prove that. I guess you're asking, how do you prove good moral character if you have a legal issue and the case has been dismissed? Is that what you're asking? Well, you prove that, one, by showing that the case has been dismissed, because if you have an arrest history and arrest record, we always have to submit your court disposition, what the decision that the court made on the case. So that's number one. Number two, if you want more things, especially if it's been fairly recent, you can get letters from people in your community, whether it's your place of work, friends, your neighbors, church, the mosque, any religious background or any community leaders that know you and know that you have a good moral character. They can also write a letter letting USCIS know that you're a person of good moral character. Okay, so Melanie says, good morning. My dad filed for my mom and it was approved, but USCIS requested for IA-24. I don't understand. I am suspecting that your mom needs to be processed outside of the US because your question is just too vague. But typically an IA-24 is something that USCIS uses to submit an approved I-130 or an approved I-360 to transfer to the National Visa Center for consular processing. So I don't know what exactly your mom was approved for, but since your dad filed for her, I'm going to assume it was just the I-130 and that your mom is either not in this country or your dad is a green card holder and she's not supposed to be here. There's so many variables. So without a consult, I can't exactly tell you, but an I-24 is basically so that they can do the process outside the US. Sub-Zero says, I love your channel. Thank you so much. How does going to the shelter help in a VAWA case? Shelter helps because it shows that you have nowhere to live because of the abuse that you face, and not having. I mean, what are the basic rights as a human being that's universal and all over the world? Food, shelter, and clothing. Those are the three basic rights. So if the reason why you don't have shelter is because of your abusive relationship, you should definitely see that it would help your case, and that shelter will definitely help. Mayor Gordon says, do you do private consultations? Yes, all day, every day. You can call the office 407-995-6567 to schedule a consultation. Okay, and you can see scrolling through the ticker. Calvia says you're doing a great job. Keep it up. Thank you. You guys are so sweet. Marlene says, what is the next step after you do biometrics for VAWA? I feel like I answered this question, didn't I? When you do biometrics for VAWA, you just wait. So I don't know if you've gotten your prima facie yet, or if you've gotten your, if you got your prima facie, but typically one of the two comes first. After your biometrics, if you file for a work permit with the adjustment of status, then you just wait for that. So that usually will come next. And once you get that, you're just going to wait for USCIS to make a decision or for them to send you a request for additional evidence. Winnie says, please, I would like to know if VAWA self-petitioners are considered individual on time-limited visa status when applying for a job with EAD. I don't understand that question, honestly. I don't understand what you're asking me. What do you mean time-limited visa? Like, what does that mean? If you can rephrase, then I'll answer. Let's see what else. You guys, when you type your questions, you have to make sure that your questions make sense so that I can, answer, because some of those questions, I can't even put the sentence together. If you wait for 1 year before your spouse petitions for you after marriage, do you get the regular 2 years or more for the green card? So what determines if you get a 2-year conditional green card is on the day that you are approved for your green card, USCIS will calculate how long have you been married. So let's say, for instance, you wait a year and you put in your application like immediately after a year, and then they schedule you for the interview in 9 months. Let's just say 9 months. If at that interview they decide to approve you, you would have only been married for 1 year and 9 months. So you still will get a conditional green card. However, on the other hand, if you wait a year and if it follows the normal scheduling that we've been seeing with marriage-based cases, and you get scheduled 12 months later, by the time they approve you, most likely it'll be 2 years. Even if it's 2 years on one day, if it's 2 years on one day, at that point you get a 10-year green card. You're welcome. Okay. Nick says, can a person receive travel documents without getting a green card? Yes, typically travel document is what you receive along with your work permit while you have a pending green card application. So when you apply for adjustment of status, that gives you the right to petition for a travel permit and a work permit. So those actually come well before your green card. Some people they might have their green card interview early and might not get their work permit and travel permit until after their green card, or they may not just get that and instead just get their call it, just get their uh, you can see questions. Um, I just lost my train of thoughts. Instagram is acting funny. This person says, I-130 was just approved. My I-45 is pending. What is next? Good. Well, congratulations that your I-130 was approved. That's a big hurdle. So your 485 pending. You should be scheduled for an interview if you've not been scheduled for an interview, because I don't know where you are in your process, whether they scheduled you for an interview already. I don't know if your spouse is a green card holder. I don't know if you entered with inspection. So without knowing all these things, it's hard to tell you what's next. But in a normal situation, that's what would be next. Oh, good morning, 1876 Aldeno. Did you stop by the office? Because we were like, who is Aldeno? We do not know who this person is. We thought it was like one of our clients. Is that you? Can you confirm if that was you that stopped by the office? Okay. Bank Cole says, is it possible for USCIS to change their mind if your naturalization is denied based on filing too early? No. Unfortunately, the way the USCIS works is that it works based on the rules of law. And what it means is that there's no wiggle room. There are things where, like for instance, credibility, like when they ask you for evidence to prove your marriage is real, that's subject to interpretation. Well, there are things that are what we call black letter law. Black letter law means there's no wiggle room. It's either a yes or it's a no. Do you qualify or do you not qualify? There's no wiggle room around there. So if you're filing for naturalization, it leads me to believe, of course, you're a green card holder. So at least you're a green card holder. So instead of just, spending money or wasting money, applying when you're not eligible, just wait until you're eligible and then file. Okay? Can you get travel documents right after marriage? That's basically what I want to know. Like I mentioned earlier, the only way for you to get travel documents is to file an adjustment of status. And if you file an adjustment of status, you can add your travel document application, and USCIS will decide whether to approve you or not. This person says, what question is usually asked for a 10-year green card? That's like a completely different live video. The questions vary to very simple and then to very complex. Maybe I can just do like another live that just focuses on Stokes interviews. Stokes interviews is when they separate both husband and wife, or husband and husband, or wife and wife. And they ask you questions about your daily lives. So this could vary. It could be as intimate as, when was the last time you guys were intimate? Personally, I think that's an inappropriate question for USCIS officers to ask. And generally, I would say, you can ask my client other questions, right? To what did you guys have for breakfast? What side of the bed does your husband sleep on? What side of the bed does your wife sleep on? Can you draw a picture? Like sometimes they'll separate you and they'll tell you, okay, draw a picture of your bedroom, draw where your bed is, draw where your windows are, draw where the TV is, and then they can bring in another couple, the other spouse, and tell them to do the same thing, and then they'll compare. They could ask you what color are your toothbrushes. They could, so there are a lot of questions that even for those of us who have been married for a long time can't answer. So when you have an immigration interview, you always want to over prepare. You should never just be like, well, we'll go there and we'll wing it because after all, we have a legitimate marriage. Because these people will ask you questions where you're just like, I know my marriage is real, but we just don't know the answer. So it's always better to, over prepare, and then let it just be that you go there and it's easy. Oh yeah, Aldeno. So that was you. Well, thanks for stopping by. I am Jay Zire said there's an I-130 notice of receipt and approval, the same thing. No, it's not. An approval means you've approved your I-130. A notice of receipt means that, this is the receipt for the case that you submitted. We've cashed your check and here's a receipt. Atai Bayami says, "Do I need to make a consultation before I come to your office?" Yes, you need to book a consultation. If you need to book a consultation, you can call 407-995-6567. We don't take walk-ins because people are scheduled, so we can leave one appointment to go to another appointment. So you always have to book a consultation. Hi, Be Luxurious. What's up? Okay. I have an approved I-130, biometrics already done, spouse is a citizen, I was F1. Yeah, so the next thing is you definitely get called for an interview. Thank you, Brandy. You love my earrings. I'm going to send it to you. I got this from Neiman Marcus. I just don't even remember the brand, but it's like my favorite earrings right now. Okay, I'm going to take two more questions, guys, and I have to jump off. Can someone who gets his or her green card through marriage and later divorce file for a green card through another marriage for an immigrant with no status? Technically, yes, but you want to make sure that you've had your green card for over 5 years, or that you're a U.S. citizen, just because, again, these are things that trigger red flags. And Ms. Blackberry says, I'm a green card holder. How long would it be for him to receive his green card if I file for him? Unfortunately for you, as a green card holder, if your spouse is here in the US, they must be in status. If they're not in status, they're going to have to leave the country. And if they have to leave the country, they have to file a 601A waiver, which could take years. So the process could take years. So the first question really that you should be asking is, when are you eligible to file for citizenship? If you're eligible, you need to file for citizenship so you can do the adjustment of status, because that would be the quickest way for him to get his green card. Okay, last question. Let me answer this person on YouTube. Do you always have a prima facie for VAWA? I have an RFE for good faith marriage and police clearance for VAWA case. Is it a good sign? No, you don't always get a prima facie for VAWA. It's not a right that you're entitled to. Like, USCIS has to believe that you qualify for that. So if you have an RFE, basically they're asking you to prove your good faith marriage, like if marriage is truly legitimate and that you didn't enter it for immigration purposes. That's what they're asking you. And police clearance is basically proving that you're a person of good moral character. And if those are the two things that you have, there's a possibility that once you send this over and it's satisfactory to them, you can get that prima facie determination letter. All right, guys, I gotta jump off. Had fun chatting with you guys. I'll see what my schedule is on Monday, and I might come Monday live on Monday. Like I said, I don't have, other than Tuesday, really, I don't have any definite times that I come on live, because it just depends on what my schedule is like. But if I do, it'll be between maybe 9:30 to 10. So you can put a notification so that you know when I come on live. All right, guys. All right, everyone. Have a safe and happy weekend. Bye.